SJC-11856, Commonwealth v. Matthew A. Mogelinski.
Oh, there we go.
Good morning, Ms. von Flatern.
Good morning, Chief Justice, members of the court. May it please the court, Cynthia von Flatern, Assistant District Attorney for the Northwestern District for the Commonwealth. 2 years ago this session, the parties were before this court on the issue of the juvenile statutes and what constituted apprehension under those statutes. And in that decision, the court held that apprehension would occur when summons or process issued against a juvenile if he were available to the court or if he were arrested or a warrant issued. So in this case, the juvenile summons issued when the juvenile was just 2 weeks short of his 18th birthday. He was arraigned, and a couple of months after that period, he was indicted on youthful offender indictments. This court, in 2 years ago, held further that those indictments were not timely and they were barred because they had taken place after the defendant had turned 18. So he was apprehended before he was 18 on the juvenile complaint, but as to the indictment, he was apprehended after 18, and so those youthful offender indictments were not appropriate. As a result of that case, the Commonwealth null-prossed the original youthful offender indictments in line with the court's decision and took out new complaints in juvenile
Hadn't they been
court.
null-prossed already before our opinion?
The complaints had.
The juvenile court complaints had already been null-prossed.
They had been, Your Honor, after youthful offender indictments.
After the youthful offender indictments.
Yes.
And so it was.
And then the indictments were
then
null-prossed.
the indictments were null-prossed.
Yes.
Okay.
So as a result of this decision, the Commonwealth went back to court. The state trooper, the sergeant, went back to court and brought out new complaints for delinquency, based on the same charges, and that was that the charges are that the defendant had raped and indecently assaulted his sister when she was between 4 and 11 years old. When it came time for arraignment, the defendant had filed a motion to dismiss, and the juvenile judge allowed that motion prior to arraignment, and that brings us here today. And the Commonwealth would submit that it was appropriate for the court, or for the Commonwealth to file these charges. They were done in good faith, and I think it would have been the expectation that this would take place. Okay, the Commonwealth was guided by the decisions in Porges, Nanny, and Mogelinski, and now we understand when apprehension took place. We understand that youthful offender indictments and grand jury indictments cannot take the place of a transfer hearing, and so as a result, this juvenile needs to be, complaints need to be brought, and the Commonwealth needs to go forward with transfer hearings.
So your point is that under 72 perenne, not 72A, this is not the same case, so that the idea that it is a continuation, that it's that the juvenile continues to have jurisdiction over children who are already there.
Yes.
You say once that null pros of the juvenile complaints happened, this is
Yes.
a new complaint.
Yes, Your Honor.
Is there either case law or practice that sort of talks about null pros in that way?
Well, I think that these facts are, I think, the first that talk about null pros in this way. We do have Commonwealth versus a juvenile, which was a case where there was a re-apprehension when there had been apprehension before the juvenile turned 18. There was the first part of a transfer hearing with probable cause, and then the defendant defaulted. The juvenile did not default in this case, but there's still that concept of if something happens so that the Commonwealth takes out new complaints, that is appropriate.
What's appropriate? I'm sorry.
That it would be appropriate to take out new complaints, to null pros old complaints and take out new complaints, and follow 72A.
72 capital A.
72 big A.
And get the
capital A.
transfer hearing.
Yes.
Is there any law anywhere, including in any other state, that would allow the withdrawal of a null pros and the reinstatement of an old complaint?
Well,
Has that ever happened anywhere?
I'm not aware in the juvenile context, Your Honor, but I think that, it frequently happens that the Commonwealth could have a case and null pros that case, and then it continues on. I think.
Well, it continues on in what way?
Well, there can be a new case. For purposes of Rule 36, the time when the old case was going on is considered, but not the time period between a null pros and new complaints. And I think that happens frequently. And I think the juvenile's position in the juvenile court was that can happen. His position was that. And that it could happen in this case. His position was simply that the juvenile court no longer had jurisdiction.
So in the Rule 36 or speedy trial context,
yes,
what you're saying is, as long as once the null pros happens, that space between the null pros and the initiation of a new complaint,
right,
doesn't count.
Does not count for Rule 36 purposes.
So it really. So we have some case that actually talks about a null pros as a Commonwealth dismissal of the case.
I think that's Commonwealth versus Dale D., Your Honor.
Justice Cordy wrote it, that's all I remember, but I don't remember what the name was.
I think Commonwealth versus Dale D., a null pros, I'm not sure if that's the case, but I think that's the, well, I'm not sure if that's the case, but there was a recent case where talking about null pros.
Oh, I know the one I'm thinking of.
So as I understand the arguments here, basically the Commonwealth is taking the position that these are brand new complaints and entitle the Commonwealth to a transfer hearing.
Yes, Your Honor.
And the defendant is taking the position that these are not brand new complaints, but really just the old complaints that have been revived?
Yes.
Right.
And that they can't be prosecuted as the old complaints?
Yes, that's correct.
But why can't they be prosecuted as the old complaints? All that happened was that they were put to sleep. As he says, put to sleep and reawakened. Why do they have to be dismissed if they were
they could not be prosecuted
kind of phenomenon?
They could not be prosecuted under the old complaints because the time periods are so short that the jurisdiction of the juvenile court has run out. So they could not be prosecuted just as juvenile complaints.
But I thought he was saying that they couldn't be prosecuted because under the original complaint, he was apprehended before his 18th birthday. And in order to proceed as you would like to proceed now, he would have to be apprehended after his 18th birthday. That's
right. If he were apprehended before his 18th birthday, then the juvenile statutes 72 little a and little b say that the cases would have to have been completed. It was before 19. Now it's 20 after the change in the juvenile statutes in 2013. And so, purely under the juvenile statutes, the juvenile would have aged out. But under a transfer situation, where a juvenile is apprehended after he has turned 18, then what happens is you proceed through. You have the juvenile complaint, and then the transfer hearing takes place, and the juvenile judge determines both probable cause, and then whether the complaint should be discharged or whether it should be the complaint should be discharged consistent with protection of society, or whether it should be dismissed, and the interest of society would have a criminal complaint issue.
Is the problem in terms of what the defendant's saying, when the statute says nothing herein shall authorize the commitment of a person to DYS after he has attained his 20th birthday, right?
Yes.
So does that mean there's no jurisdiction, or does that just mean that if the person if there's a complaint and he's adjudicated a delinquent, he can't be, there's no real sentence possible. Is that, I was just trying to figure out if it's jurisdictional or it's a question of disposition.
Well, I think, and I believe there's chapter 119, section 74 says, the only way you can get to juvenile court after you have turned 18 is with
through the 72 capital big
yes,
A.
Yes.
Okay.
And now it's actually changed to after you have turned 19.
Right, but I get it. I wasn't looking at 74.
And there are. I think there is a jurisdictional issues. I want to just bring the court's attention to Commonwealth versus Porges, where this was first discussed, and then it was also discussed in the Mogelinski case. In Commonwealth versus Porges, the argument was that the juvenile had committed sexual assaults before he turned 14, so he was not a youthful offender. He could not be indicted as a youthful offender. And then the question was, could he be indicted at all? And he could be. Juvenile complaints could be brought against him before he turned 18, but once he turned 18, he was subject to transfer hearings, and he was apprehended after 18, so he was subject to transfer. And the court there said that is fine, but there is the possibility that there would be a due process issue if the Commonwealth had acted in bad faith. And you could see why the Commonwealth, in a situation like that, there could be a possibility of bad faith if the Commonwealth had only delayed apprehension so that to take the juvenile out of
transfer hearing.
Yes, and put him into the realm of a sentence as a felony sentence, and not just delinquency under a juvenile complaint. But in this case, there was no bad faith. You have the context of youthful offender indictments had been brought in this case while Nanny was pending, and when Nanny was pending, the district attorneys, many believed, and the record would be clear in Nanny, that the district attorney's position was that transfer was not necessary, and that an indictment under a youthful offender could occur after the juvenile had aged out, because you had that protection of the grand jury indictment. And this court in Nanny said no, that transfer does not take, or youthful offender indictment does not take the place of transfer. So that was we had already proceeded under the youthful offender indictments when that decision came down. And then Mogelinski case was important because it said that the youthful offender indictments cannot take place, even if there's a complaint before age 18, that the youthful offender indictments can't take place after 18. But again, there were questions at Mogelinski, at oral argument, as to whether there was any double jeopardy issue in this particular case, and there has not been. So that would suggest there is no double jeopardy problem, there is no statute of limitations problem, that it is fair, and when the Commonwealth acts in good faith, for the Commonwealth to go back and seek the juvenile complaints.
There is a statute of limitations problem with respect to some of these, some of the alleged acts?
I don't believe that there would be, Your Honor.
I thought, maybe that was, because I thought by the time you brought the youthful offender, there were some of the earlier ones that you didn't pursue.
The reason that we didn't pursue under youthful offender is because the juvenile had committed acts before he was 14, and so he would not have been a youthful offender.
But for us to agree with your position, do we have to essentially conclude that a person can be apprehended more than once for the same crime?
I would say yes, Your Honor, and I think that there is some support for that in Commonwealth versus Juvenile, where there was 2 apprehensions, and just in the concept of Mogelinski, which was that you have a juvenile complaint and then you have youthful offender indictments, and they have 2 separate apprehensions. So I think that that's fair to say that we would have to say that there were 2 apprehensions.
What is the site for the Commonwealth versus the juvenile that you just mentioned with the 2 apprehensions?
Yes.
Because you have 2, and I see 2 in your brief.
I do, Your Honor. It's the earlier one. 16 Mass App Court 251 at 257.
Thank you.
Could I ask a clarification? Is it the Commonwealth's position that offenses that occurred before age 14 now may be brought?
Yes, I think so, Your Honor, because it's not a youthful offender situation any longer.
Yeah, so what would be had been the situation if you had been allowed to proceed? For anybody in a position, could they be proceeded against twice, once for those after the fact, if the age frames were correct, and then wait till he's older and then go after that same individual with respect to those as to which you couldn't have proceeded against him in the juvenile court?
Well, possibly, but I think there might be a double jeopardy issue. In this case, you'd have to be the
different offenses.
That you'd have to make sure that they were different offenses. And here, there's continuing offenses, but
I'd also think you'd have a bad faith argument on that.
Yes. You'd have, I think, an argument for overreaching in that particular case. But in this case, again, we have. I think that the record and the timeline would show that there was no bad faith. We still have this young victim who is willing to go forward, and we still have the protection of the transfer hearing for the juvenile, at which time the victim would also have to testify, and the court will not only determine probable cause, but what is in the interest of society.
Thank you, Counsel.
Thank you.
May it please the court, my name is John Ouderkirk, and I'm here on behalf of the juvenile. I say juvenile because technically he's not a juvenile anymore, but in terms of the standing of this case, it's still, at least whatever is happening on delinquency complaints, not on adult criminal complaints. If I could begin by answering Justice Spina's question, yes, there is law on the question about the nolle pros. It's an absolute wonderful decision that this court wrote in 2014. It's cited in my brief. It's Commonwealth versus Dehaney. And basically what this court said was, and I believe it was Justice Lenk that said about putting to sleep and reviving. What this court said was that a nolle pros does not extinguish the complaint, that it only indicates that the Commonwealth has decided not to pursue prosecution of the case, but it's not an indication that the case has been dismissed or extinguished or that there is any lack of evidence to go forward on the case. And hence the argument that I made, which is if you say that these cases were nolle pros and they were just put aside, so to speak, put in the back of the refrigerator, and now we take them out, they're the same cases.
What's the practice, though? If a district attorney's office nolle pros a case and then 10 years later they get new evidence, they want to revive it, do they file a new complaint?
What you file is called a notice to revoke the nolle pros.
All right, okay.
And
have you ever seen one of those?
I've never seen one.
I haven't either. I mean, wouldn't you ordinarily just get a new complaint or a new indictment?
You're supposed to file the notice in the court that entertained and allowed the nolle pros.
Is there a rule that relates to that? Or is that
Not
just
that I've ever seen, but that's what my understanding of the practice is.
Did you just make that up, or I mean, is it?
No, that's my understanding of how it's done. Is that you go to the court that granted the nolle pros and ask them to take it back.
Is that discussed in Commonwealth versus Dehaney?
It's not specifically discussed in Commonwealth versus Dehaney. You hinted at that because you talk about the
That's
notice
the Rule 36 problem. Isn't that
I'm
the
sorry?
Rule 36 case? Is it a Rule 36 case?
Yes. But in any event.
So how does that get reconciled with Commonwealth versus a juvenile, which I presume is the one we just referred to, which has to do with the default post-apprehension, and it was appropriate to nolle pros it and then take out new complaints. How does Dehaney square with Commonwealth versus a juvenile?
The magic word in there was the default, because at the time that the juvenile defaulted in the prior case, he no longer enjoyed the continuing, well, in this case, protection of the existing complaint.
But it was still a null pros, right? So we're talking about what's the effect of the null pros, not the question of whether or not there was a default, right? I mean, because the result was still a null pros.
My response to that would be that the difference was the default. The default created a break in the procedural process, the same as a dismissal would cause a break in the procedural process. And I suspect if the Commonwealth had dismissed these cases rather than null pros them, and I understand from the argument that the other side made, the reason they like to null pros them is because it doesn't count as Rule 36 time. But the downside,
would it also avoid a potential statute of limitations problem?
Mm-hmm.
So the point of that is that here, what you're saying is, what the Commonwealth really needs to do, having null pros the complaint, is the original complaint, is to revive it, and by virtue of reviving it, this defendant is now being apprehended, but it's the apprehension is still before his 18th birthday, so the statute doesn't apply.
Correct. If they revive the null pros charges, he's already been apprehended on them. And you're correct. He was apprehended before he passed the adulthood test at the time, which would mean that the 72 capital A would not be available to the Commonwealth because he was apprehended before while he was still a juvenile.
So no transfer hearing and anything would have to go on in juvenile court, but the Commonwealth just says it can't because of the time constraints.
Because he's aged out.
Yeah. So
I missed your reference to statute of limitations. I mean, if a case is null prost and then is revived many years later after the statute is run, the revival doesn't relate back to the original null pros.
Oh, I'm sorry. I was talking about the amount of time for speedy trial.
Oh, speedy trial. Okay.
During the period that it's null prost, it doesn't count towards speedy trial time. I'm sorry if I was confusing on that.
If there had been, if the Commonwealth had sought leave to dismiss the complaints upon filing the youthful offender indictment, would you be in a different place?
I believe I would, and I believe that was discussed in the dissent in the original Mogelinski discussion. There was some information that was posited as part of the hypothetical in that dissent, and I think it would lead me to be in a position where I would have to agree with you. I would have a much more difficult time had they done that.
So why should we give, I mean, the Commonwealth could have done that. They could have sought leave to dismiss. And why do we give so much consequence to that matter of form?
Well, I think in any manner of trial, whether it be civil or criminal, the attorneys make tactical decisions, and those tactical decisions have consequences. And the consequences on either side can be pretty grave. On the defense side, the consequences can be jail time, considerable jail time. So I think when you get into an adversarial forum such as we have, there are consequences to the decisions that we make, tactical or otherwise. And if the Commonwealth did it wrong, the Commonwealth did it wrong. If nothing else, it stands as a signpost to future prosecutors how to do it right.
I'm sorry, and tell me again the practical difference between saying, Your Honor, we wish leave of court to issue a null pros versus, Your Honor, we wish leave of court to file a motion to dismiss.
The null pros means that the original criminal complaints are still in effect. The null pros just says, Your Honor, we have chosen not to go forward on them, but we have not chosen to extinguish them. They are still there.
Is there any case law that suggests that taking the null pros route, in fact, would avert a statute of limitations problem?
I do not know of a case that would specifically address the statute of limitations problem. No, that I do not know. I know that your case in Dehaney was very clear about delineating the difference between the effect of a null process.
That's for counting purposes for Rule 36 was the context.
Well, I know, and I realize it was a different context, but it was very eloquently written.
Well, I know, but I actually read it differently than you do. But that's okay.
And I'm sorry, so it does not extinguish it, and is it your view that a prosecutor can immediately say, I've changed my mind, I wish to, without leave of court? I gather it requires leave of court to revoke.
Yes, it requires leave of court, but yes, they can do that. And
but only with leave of court.
Dehaney is not exactly clear on whether it's only with leave of court, because Dehaney talks about bringing it back before the original judge that granted the null pros.
Dehaney talks about that?
I believe so, and I think I mentioned that in my brief at...
Page 4?
I think I mentioned that as at page 734.
And if I guess, I'm sorry, if you're right, does that mean that we're giving the Commonwealth much more leeway to renew a case when it files a null pros than when it moves to dismiss?
I unfortunately would have to say yes. I believe that is what it says.
So if the case were dismissed as opposed to null pros way back when, if it were dismissed, then the Commonwealth could bring a new complaint, and Section 72, capital A, would be available to the Commonwealth, because I take it a person can be apprehended twice for the same crime.
I would say as long as jeopardy had not attached, they probably could be apprehended for the same incident, the same offense. There is a question, and this is an open question, that once you get to the grand jury in the indictment process, does that constitute a finder of fact taking evidence, and does jeopardy attach at that point? There is one argument that says there is. There are several arguments that say it is not. That's a question for another day, and it really isn't part of this case, but it is an interesting question.
But the null pros here, as I recall it, was done because the Commonwealth had obtained a youthful offender indictment and could not proceed both on the complaint and on the indictment.
But at that point, they had a choice to null pros or to dismiss, because the indictment was still valid because the case hadn't come here yet. At the point they made a decision to go with the indictment and not with the delinquency complaint.
And if the Commonwealth had proceeded to indict but had not null prosed, what would have been the legal consequence?
I believe that they can keep both going until jeopardy attaches on one or the other. That having the indictment and having the complaint simultaneously is not a problem. But once either proceeding attaches jeopardy, then the other one has to go away.
And here there was no jeopardy that attached because of the motion to dismiss.
Correct, because of the opinion from this court and then the return to the juvenile court. They never got past testimony to the grand jury. That was as far as it ever made it. Just briefly, as my time winds down, I'd like to mention the fact that there is absolutely nothing. Humberto H. is the one case I've cited in my brief. There's nothing in the rules that prohibits a prearrangement motion and a dismissal prearrangement. As a matter of fact, Humberto says it is the preferred practice to postpone arraignment until after the defendant has had a meaningful opportunity to consult with their attorney. I submit that means that their meaningful opportunity to consult would entail decisions about prearrangement motions. The trial court judge did, in fact, specifically find that she was dismissing it because of the juvenile court's obligation to protect and create a...
Okay, sorry.
No, go ahead.
No. I wanted to ask you a different question.
Okay. To protect the juvenile, and by doing it this way, she prevented there being any entry on his carry.
My question was, I think you argue in your brief that if we get there, the Commonwealth did act in bad faith, and I wonder, why do you think that?
Well, I think to a certain extent, if in fact the Commonwealth should have been aware of the fact that they were bringing the exact same offenses, and you can create new charges anytime you want to, but the statute doesn't talk in terms of the date of the charges. The statute talks about the date of the offenses, and everybody knew these were exactly the same offenses. They knew the date of the offenses. They knew the juvenile had already been apprehended on these offenses. I think at a certain point they should have said, we've come to the end of the road. We just aren't going to win this one. And whether it's our fault, which obviously we're insinuating that it was tactical mistakes on the part of the Commonwealth that led them to be in the position they're in, or not, that there was really such a slight likelihood that they would prevail, that to go ahead and bring everybody back into court and start all this over again just simply wasn't right.
All right, thank
There
you.
are no other questions. Thank you.
Thank you.